And I'll also start sharing my screen. To be fair, I know it's a great opportunity with these virtual workshops to get everybody from different countries, and this wouldn't be possible, but I actually really hate them because I miss the vibe of being with people. Okay, so I hope you can see my presentation now. As Olympia mentioned in the intro, today we will be covering the legal aspects of a maritime startup. See whether you're ready to sell, where you need any help with, and try and support you in that. I know this is the first workshop, so no pressure there, as Alexander said. So let's see how it goes. Olympia did a very good intro on me, but just to mention what Ocean Arena does. So we make sure we protect your legacy. We are a startup for startups and provide a global legal network around the globe. So any jurisdiction you're in, we can solve that matter. It's a very approachable kind of team, and we're very tailor-made to accommodate the startups and the visions there and basically help you brand and secure your legacy. So first of all, congratulations. You are the first cohort, obviously, of the ClimAccelerator, very exciting journey. And today we're here to make sure we get you set on the right track. From what I understand, we've got 25 amazing startups. I mean, I've already been reading some in the chat, great initiatives, 7 jurisdictions. I've already asked you to do that when we started. So what does your startup do? Where are you based? Do you have a legal strategy in place? That's kind of a new question. For anybody who hasn't shared, do go ahead and share. Would be very useful for me also to see how I can support further during the course of these trainings. So starting with the elements of a successful startup, if you're here, you pretty much know a few of them. So a great idea, obviously, solving a solution, a great team, and a network. So what else do you think would be missing from that composition? Any thoughts in the chat? What would be the 5 elements for a successful startup? I guess it is quite obvious since I'm here today, but to make it even more clear, a good lawyer. As this persona says, whether you like him or not, in suits, the only time success comes before work is in the dictionary. So hopefully you won't be needing a Harvey Specter, but in order to be safe and dry, while I know you're being creative in this very entrepreneurial journey, there are a few things you need to make sure that your legal formalities are in place to save you from a mess to success and vice versa. Yes, Anne was right, understanding the legal framework. If at any point there's any technical issues with the presentation, do let me know, because I was having some earlier. And customers, of course, are a very important element, but you do need to get some fundamentals in place before you embark on that customer journey. So our areas of focus today are going to be 5. I would group them into 5. There's much more, but I will try and simplify this for you, because I know sometimes legal is a challenge and you can't get your head around it. So it's incorporation of the company. So what legal vehicle to use. I don't know if you already have your company set up. If you would like to share with us what you've been doing so far, that would be great. Then it's the policies. So like when you're setting up your website, terms and conditions, GDPR, privacy, and all that kind of boring stuff. I know, but they need to be there. IP protection, that's super important. Most of you are building a legacy, a new solution. So you have to make sure that you've got that copyright and patents in place. Whether you need international protection, it really depends on your product and what you're doing. But you could have to be applying on an international level. So you need to make sure that the legal support you're getting is on a global kind of level. I will be going into detail to all of this further on, but these are just the main pillars of what we'll be discussing today. Then, of course, we've got contract management. Contracts are very important, especially you mentioned the customers when you're dealing with clients. The earlier on you've got a template for this that you can adjust it better. I will be giving some tips today on the most important clauses, which obviously would be terminating force majeure clauses, which might be unknown to some. It's like to make sure that in the event, say, of a pandemic, if you've got an agreement in place, you can easily waive that liability. The jurisdiction is very important. So what would happen in an event of a dispute? And this would cover basically any form of agreements, even from your shareholder agreement, if you've got co-founders, to the vendors, the suppliers, NDAs, any form of agreement. You need to make sure you've got something in place that will more or less secure your rights. You can never foresee for everything, but there are some key terms that you need to have in place, and you would be surprised how many contracts I've seen without a termination clause. I mean, it's just something you might not consider, but it's quite important. And then finally, for those of you that are looking to scale up or might already have a team, some employment matters. So the contracts of your employees, if you have to terminate, and how you go about that, that's quite important. I know that for a startup, these considerations do not really come up on a daily basis, and you think we just go with the flow. But these today are just some good things to keep in mind going forward, hopefully scaling up, and depending on whatever your needs are, of course. So the why, as we mentioned in the intro, today I thought I'd cover the 15 big legal mistakes that startups made. This is according to Forbes, and through my personal experiences working with a few. So what do you think, and this would be quite interesting, is the first mistake that a startup makes when it comes to legal matters? Any thoughts on that for anybody? I mean, feel free to share what you're thinking, and let's see what you're guessing. Disclosing too much information from Anne. Yes, that's true. Not writing a clear contract. Again, a very important IP protection, definitely very important, especially if you're dealing with patents, but even copyright nowadays, and even your company name. Having NDAs in place, yes, confidentiality, very important also. Any other thoughts from the audience? What's the number one mistake? And every time I ask it, nobody really finds it. So I'm looking forward to see if this audience will. A shareholders agreement, yes, Javier, you're down the right line. So yeah, the biggest mistake is actually not knowing that a business relationship is not the same with a personal relationship. And you need to really set out the key and conditions when it comes to co-founders. So I know what happens with most of the startups, right? It's a team of friends or team of peers from college, or even spouses, high school friends. They get together, they have this idea, and also mention the shareholder agreement. You say, okay, we'll be the founders, we'll put this together, we start it going, all the enthusiasm is there, the passion is there, you know exactly what you want out of it, you've got the vision, you've got the solution. The thing is, though, that unfortunately going forward, you need, no matter who your co-founder is, you need to have a shareholders agreement in place. And I know that this relationship mainly lies in trust, and no contract can secure that trust, but a lot of things can be avoided if in that shareholder agreement you've set out and pre-agreed on a few key elements. So on those key elements, these are quite a few considerations that you should be taking in mind, and try and be as clear as possible. So the equity split, obviously, if you are putting your own funds on the line, who is putting what? The roles, so the better you define these roles, and the clearer the differentiated, it's the best solution going forward. It's even better if you can diversify. So if one is very good at client relations, for example, and the other one is very good at the technical aspects, if it's as clear as that, do make sure you've got that into the agreement, and you've got a very good understanding, raise that discussion of who will be doing what, so you don't get into any legal hiccups, as I like to call them, because unfortunately, the startup journey is a challenging one. It's not an easy one, I know, and it's not always a smooth ride. So especially when you're tense, you're trying to find the funding, you're trying to keep things going. Most of you don't even get salaries for the first few years. So it's quite important that in that tension kind of zone, you've got a very clear understanding and you're very aligned with your co-founders. So putting this in writing and having this discussion early on in the stage really helps. So also, how will your decisions and day-to-day decisions of the business be made? Will it be by majority vote? Will the CEO be able to decide? Will it be an external CEO? Do you both agree on that? Will somebody have the authority to decide on specific issues and the other person will decide on other issues? These are kind of considerations you should be putting down there. The levels of participation expected for ownership level. So are there any constraints of what you're expecting from each other? Is there a particular level of participation that you feel you both agreed? I mean, end of the day, you don't want one person doing all the work and the other one not doing anything and saying they're a co-founder. So that's also quite important. If there's any restrictions in this, so say if one of the co-founders is working for another company and this is a side hustle, maybe you would like to fine-tune that role and level of participation to make sure that there's no disappointments or that you're not meeting expectations from either side. Then what happens if one of the co-founder isn't living up to the expectations or under this founder agreement, right? I mean, the more clear you make what can be the solutions, the better. Because it happens, life changes, it might take longer than anticipated to reach some goals and somebody might lose that motivation or no longer be able to commit. So make sure you've got that clearly set out. Under what circumstances a founder can be removed? Would that be a board of directors decision? Just try and figure out the operational matters of this. Clearly state what assets or cash does each founder contribute or invest into the server. So something like an inventory when you're renting a place or buying a place, it's always good to put down what each has contributed or what they will be contributing, just to be on a clear note. And what would happen to those assets, for example, and that cash is if somebody wants out. If one founder leaves, does the company or the remaining founders have the option to buy the shares? And if so, at what price? Can that founder sell it to another person? These are quite important considerations to go into a shareholders agreement. And when I will be talking later on about the type of company that you incorporate, especially so if you decide to go with a partnership, which is not recommended, I will analyze later on, but especially so you need to know how those shares will be distributed and what happens to the company. What salaries, if any? I know salary is a thing for the first year, especially, but what salaries are you entitled to? And how can that be changed? What is the overall goal and vision for the business? And make sure this is documented. So sometimes you have that idea, right? And you have that passion and you don't quite pin down the details of if you're aligned. For example, you might personally want this brand to grow and scale up and sell it and go into a merger and acquisition, and your partner might not have never had this thought at all. They might just want it as their own baby and want to see it grow, and this should be discussed and respected. For those asking about the presentation, we might be making it available, but you would be definitely getting a link to the replay that will be available for 30 days, a private link for this cohort. As I mentioned also earlier, the overall goal and vision of the business. So set it out together. Make sure this is also documented. Where do you want this to go? It might be too early down the line to see whether you want to sell it or going forward, what's the purpose of building this company. But it would just be good to have this discussion with your partner, make sure you're more or less on the same side. And of course, in the event of the sale, how would the sale be decided? Would it be of equal standing? Would you be taking and considering some criteria? If you're at a more mature stage, what would be the price that you would be happy with, or the arrangement? Would you stay on as management? That kind of stuff. are quite important. Try and put as many as you can in a shareholder agreement. Again, I know it's all about trust, but the more you discuss and understand each other's needs, the better to make sure that this is a win-win situation for all, and you don't find yourselves 6 months down the line or 1 year down the line trying to build this startup and also having the burden of sorting out issues with your partner, because that can really, really ruin the motivation of a startup. So mistake number 2 has to do with the incorporation of the business and what kind of vehicle you choose to run this business, your startup. So most startups might actually just start with the idea, might not even incorporate a company. If they do, some might go with sole proprietorship. So that's a sole trader basically. But it is quite important, and I know that the budgets are usually low and you don't want to be too like legal stuff is you put it under the carpet and you just deal with it if it comes along, but do try and consult a lawyer. It's not just me, there's a lot of firms that now cater to startups, so make sure you talk to somebody. If you also interact on a global level when it has to do with taxation, make sure your firm and your legal counsel is aware of the global impact that your decision may choose. These are very general guidelines, so please don't read too much into it. I'm just going to give you a general overview. And of course, I saw we've got people from the UK, the USA, from Belgium, etc., from Malta, Israel. So very different jurisdictions. So as I said, do consult somebody who either works on a global basis or is local to make sure you've got this right. But choosing the right corporation can really help you avoid higher taxes and any significant liabilities going forward. For example, a sole proprietorship, so a sole trader, basically, that's what we call it in the UK, for example. I think proprietorship is in the States, has less legal requirements. So there's not really a lot of formalities when it comes to filings with the register and other details that you need to share. But it definitely is much more restrictive when it comes to funding. It might also make it more difficult for you to get funding because sole traders are not really the most professional kind of vehicle to run your business. It's considered more of a freelancer thing. So a lot of creditors and financiers might not be willing to finance you, and some might actually not. A general partnership, which I mentioned earlier, and I said try and avoid it. So the rules of engagement are usually regulated by statute, or preferably, if you do choose this option, a partnership agreement. So when it comes to a partnership agreement, the income of a partner is taxed directly to the partner, generally on a pro rata basis to the percentage of the business ownership. But each partner is liable for the debts of the business, which that person, that such personal assets of each partner are exposed to a full extent and full liabilities. So you're very exposed in this structure. There's minimal protection. Under some jurisdictions like the UK, also if one of the partners steps out, you have to dissolve the partnership. So as I said, this is not really recommended. Sorry about that. The beauties of going virtual. And as I said, we don't recommend the partnership. It is used in some kind of form. So it's used a lot in law firms, for example, because it's a completely different arrangement and there is personal liability there. Somebody's asking, what is the translation of this legal figure to the Spanish regulations? I can get back to you. So if you would like, I'll be sharing my email at the end. So for particular jurisdictional matters, as we're quite diverse in this audience, I won't be able to go into all jurisdictions, but please feel free to DM me. And as I mentioned, Ocean Arena has a global network. So I'll get my counterpart in Spain to get back to us on that with full details. And then we have the LLCs, which are legalities under the state law. This is a hybrid form of corporation and limited partnership, and it has certain tax advantages. So it provides limited liability and protection for the founders, which is very important, I would say, and also provides for flow through taxation to the members. So if you plan on bringing, though, what you must note here, if you plan on bringing in a venture capital investment at some point, it's best to avoid starting an LLC. While it does give limited liability, venture capitalists cannot really invest in pass-through entities. So that might be an issue going forward. Now, mistake number 3, as I said, I'm moving quite quickly through them, and it's a general overview because you're from quite different jurisdictions, but I will be sharing my email and details at the end for any particular jurisdictional matters and considerations that you would like to discuss further. So mistake number 3, choosing a company name that has trademark issues, problems, etc. So domain name issues. So the first thing you have to do, if you haven't chosen your name already, or even if you have and you haven't set up your company, do some research, because you may be infringing somebody's trademark if you use a mark that is likely to cause confusion among customers, sorry. And you might be confused as being a part of the group, which may create further issues, especially if they're a very big group. So you need to avoid, any names that are similar, that look similar, using colors, similar logos, all of that would go under an IP breach. So do make sure of it, because especially some of the bigger companies do take this very seriously, and you don't want to end up with a court case and having to pay lots of money in damages. So I would advise the first thing to do, if you haven't already, just do a Google, start with the basics, a Google search. Then you can also check personally on your trademark office in your country. There should be a website where you can put the name in and have a look, and the companies register. If not, a lawyer would definitely be able to do that for you. Also GoDaddy and websites for domain names. So make sure you check those out and see how it goes. This is probably something that you've already come across in any other startup training. So make sure your name is distinctive and memorable. As I mentioned today, I feel very passionate about startups, especially in the oceans industry and those that are working towards technology solutions for sustainability. So you're building a legacy here. So make sure that name really aligns with what you're about. That's why at my practice, we also do the brand strategy. We also assist startups with the brand strategy. Just being memorable is quite important, because as these companies that you may be infringing the trademark take it quite seriously, hopefully going forward, your trademark would also be quite distinctive and important to the world. Also, another thing you might want to consider is don't make the name limiting. So you can need to, so then you will need to change it if your business changes or expands. So I know it might seem like a great idea, and you're probably being told to make sure your name really, people see it and understand what you're doing. But if you've got any plans to expand, or if there is a possibility for your company to be growing in slightly different directions, make sure that your name can more or less cover a wider umbrella. And then also think about international implications of your chosen name. For example, you don't want to choose a name that could turn out to have an embarrassing or negative connotation in another language. If you're working in other markets, maybe it's good to ask a colleague there or some local acquaintances, just to make sure that there's nothing in your name that may create any embarrassment. I've put in a note here. It also really depends on how global and international you are, if it's a patent, if it's copyright, but you might be needing an actual specialist intellectual property lawyer, just to make sure that you don't encounter any issues when it comes to your company name. Because another thing, and coming from the brand strategist hat, is that, say if you're striving to build your name and your strategy and you've got it there and your brand is out there for the first year of running, and then a year down the line you realize there's an issue or a claim comes in or a notice comes in and you need to rebrand, that's probably the last thing you need once you've been struggling for a year to put your name out there. So these are quite important considerations when it comes to choosing that company name. So this has to do more with selling stocks. the public listings. But mistake number 4 is not complying with securities law when you're issuing stock to either angels, families, or friends, because I know a lot of people in the startup community might be doing that, especially if you're trying to get some funding from within your network. So the sale of stocks, limited partnership interests, or LLC interests to the founders and later investors will be subject to some kind of security law wherever you are. Most security law requires that the sales comply with certain disclosures, filings, and from requirements unless there is some kind of exemption. Failure to comply can result in significant financial penalties actually for the founders and startup company, and surely that's not a burden that you can handle at the moment, and you shouldn't be able, it can be easily avoided just by getting the right kind of advice and making sure that all your documentation is in place. I will be talking a bit more about documentation going forward. And there can also be fines and other penalties, so even criminal liabilities. So this is a tricky one for failures to comply with the securities laws. So in order to avoid this damaging and maybe fatal consequences, finders should hire knowledgeable lawyers to document the sale of shares in compliance with some laws. I know it really seems like a sale pitch for lawyers, but having seen so many things, there's a lot that you can, a lot of hiccups you can avoid with just, and it's really worth the trouble of going down that road. I see I've got a question there. We will be taking them at the end, but I'll just see if it's related to this. Having invested heavily in the company, the name in which was pulled off the shelf and is not one that I would have chosen, can I operate under trading name for branding without losing the investment today? Yes, you can. It depends on your jurisdiction, but in most jurisdictions, you can register another trade name under that existing branding. But again, as I said, we can discuss it more at the end, or if you send me an email and I can get back to you with more details. Just to remind everybody, feel free to share your thoughts, and questions in the audience. That's what we're here for. That's what we'll be doing for the next hour and a half. I know not all of this might be relevant to you, but it's just very good considerations to have because you really don't know where your company may be going. So mistake number 5 is not adequately taking into account important tax considerations. I mentioned this earlier. Sometimes, for example, if you go in the direction of a sole proprietorship, you might be paying more taxes than you should have. And that, I'm sure that's not something that you really want to be doing. So without proper planning, founders can find themselves or the startups liable for unintended and unanticipated taxes, fines, and penalties. This is also quite important if you're doing this as a side hustle. So if you're working somewhere else, or in the way you're reporting your personal incomes, because this is a twofold kind of thing. So key tax considerations, obviously obtain a tax ID, choosing the right legal entity, seeking any tax incentives. Some companies do give a lot of tax incentives, and especially for startups. I know the UK does, I know Singapore does, and I think Cyprus is actually working on it. So do look into what could work best for you. Then stock options, any sale taxes, payroll taxes, employee versus independent contractor issues. I'll analyze this a little bit more towards the end, and probably documenting all income and deductible expenses. So these are accounting, super fun stuff. I absolutely hate accounting, but surely you can get somebody to sort that out for you. And they are quite important when it comes to managing your budget. Mistake number 6, not having the right legal counsel. Again, that's a sale pitch for me. No, but I'm just trying to help here. So make the best use that you can. So I know that in a misguided effort to save on expensive startup business, often will hire either friends or inexperienced legal counsel, or the cheapest one available, those offering discounts, etc. And then you deny yourself of the right of an experienced counsel who can really help you save money actually and avoid many legal problems. As I said, there's a lot of counsels that are really trying to work in line with startups and within the budgets. That's what we're trying to do. And I know that it's a kind of new thing over the last year. So do a market research. I mean, if you Google it, you can surely find and compare and prices and everything, and you can find good and high caliber lawyers that can really guide you through the process. Most of us also give a free consultation or discovery call. So make use of that. Really do invest some time in finding a lawyer that it's also about chemistry, like somebody who can get you and understand your needs and who will really care to protect your startup going forward. So these are the types of law that a startup would probably need to have in mind: corporation, commercial securities, contract laws, employment, compensation and benefits if you've got employees, intellectual property, real estate, even if you're going to have a physical presence, tax laws, franchise laws if you're planning to franchise your idea, data security, cyber privacy. And as I said, most of the councils will probably offer it. It's just very important to find somebody that understands your problems, is quite experienced in this sector, and can support you in more or less most of them, because obviously you don't need a lawyer for all of these. Mistake number 7 is not maintaining proper corporate and HR documentation. So this is a twofold thing. If you've got employees, the HR documentation is also important, if not just focus on the corporate documenting. This can become problematic when the company pursues financing, especially if you're getting some financing from loans or banks or other companies. If you're involved in a merger or acquisition, so if you're planning to sell going forward or being bought out, or if you're involved in any claims or litigation, hopefully not. Hopefully you've got the idea on getting a good lawyer on board so you don't end up in any claims or litigations. But no risk is unforeseeable. So these are all considerations and why you should have your documents in record. You really need to be evidencing stuff from day one. So the type of documents that you should be properly keeping at hand is board and shareholder resolutions and minutes. So anything you've agreed on, any changes, etc. Signed contracts, so including any documentation reflecting loans to or from the founders of the company and employees, any type of financing. Stock and option records, including among other things, the stock option plan documents, purchase and option agreements, the proofs of payment, any election forms, any IRS forms, any forms that have to do with the whole sale of shares. Job applications and resumes, you will also have to have a data protection policy in place. I will come on to that later. So if you've got employees, you should have that, as well as their offer letters and their employment agreements. Mistake number 8 is not determining which permits, licenses, or registrations you will need for your business. So I know you're quite a diverse audience here, and it really depends on what your product or service is all about, and how mature your business is, and whether you're going to have a physical presence or not, if it's going to be in one country or in many, etc. So depending on the nature of the business, you may need some permits, licenses of qualifications, such as industry-specific permits for regulated businesses, state qualifications to do business, sales tax license, or other permits, home-based business permits. Some of the startups start from home, especially during COVID, everybody was starting from home. So this is quite important. If within the jurisdiction that you work, you need a home-based business permit. I know, for example, in the UK, when you're renting a place, most of the landlords will have a provision in the contract that you cannot conduct business from here. So you would probably have to get some kind of written authorization and take this also up with the company's registrar. City and county business permits or licenses, any zoning permits, sellers permits, health department permits, federal and state tax employee IDs, etc., that kind of stuff. As I said, again, it really depends on what you're doing. So coming on to mistake number 9 is not carefully considering intellectual property issues. I made quite an intro earlier, and we've already touched upon this, but if you've developed a unique product, technology, or service, you need to consider the appropriate steps to protect the intellectual property that you have developed. So both the company's founders and its investors have a stake in ensuring that the company protects its intellectual property and avoids infringing the intellectual property rights of any third parties. And also making sure that you're putting your own strategy in the right way, in the best way possible. So some common protective measures, I will not go into too much detail on what each is, but would be happy to answer any questions at the end. But some that startups will come across are patent rights, copyrights, trademarks, service marks. So they resemble a trademark, but are used to identify a service. This is not available in all jurisdictions, but it is something to consider. For example, I know in the States you do have service marks. Trade secrets, that's also quite important. You know, the most common one obviously is the Coca-Cola. That's a trade secret. So if you're developing something as exciting as that, do make sure you take this into consideration. Confidentiality agreements, of course, any discussions you have about any of the projects you're working on and with any supplier, even your own employees, and I would come on to this a bit later on. Make sure you have those NDAs and confidentiality agreement in place and penalty clauses of them nonetheless, because you need to make sure that people know you're taking it seriously. And any confidentiality and investment assignments. So if you're co-working with somebody to develop something, make sure you've got that contract in place. These should be taken into consideration for founders and investments to avoid any claims by also some prior employer that the intellectual property contributed by the founder was misappropriated from the prior employer. So what I'm trying to say here, so say if you work somewhere and you've got a few ideas, or you have even maybe decided that you can use some of that strategy on your own, you need to be really careful going forward when you're setting up your own startup, because your previous employer might come back to you and say that, you know, you're not allowed to, as per your agreement or as per what we have been discussing, or the company policy, you were not allowed to do this. So make sure you're quite aware of what you can and you can do when you're trying to create your own startup. Mistake number 10 is not coming up with a great contract. Some of you mentioned the contracts at the beginning, and I'm very heavily into contracts, and I know that it's not always the case when, like, it's not the perfect solution to be taking somebody to court for a breach of contract. But what that does, so what a great contract primarily does, especially for a startup, it shows that you mean business and that you're serious and that you've got the right terms and conditions in there. So what you need to make sure is that the contract clearly spells out basic terms, such as a description of the deliverables, agreement of the pricing, when payment will be due, what penalties or interest will be owed if payment isn't timely, how the contract can be changed, most commonly only by written agreement of the parties. Make sure you put that in. And all of these considerations, the clearer you make things, the better. So if you can use dates, exact figures, interest rates, make sure that's all in there. It might take a bit longer than usual, but what I would suggest is putting together a template that you can kind of fine tune depending on the condition, but have that there to make sure you don't forget anything crucial. So minimize or negate any representations and warranties about your product or service. Make sure you're not saying something that you cannot deliver in that agreement. Make sure that you've limited your liabilities as much as you can for any unforeseen circumstances, or even if it's something that could come up because you do not want to be found in breach, you do not want to be paying penalties. And most of all, and the most crucial thing for a startup, is you do not want your reputation to be damaged. So make sure you can deliver what you've put in that agreement, because if you're going about with your first contracts and you've put something that you cannot deliver and you're not delivering, that won't really work for you going forward. So that's quite important also. Including limitations on your liability if the product or service doesn't work or fails to meet the buyer's expectations. Obviously, this is quite a tricky one, and you don't want to seem like you're trying to waive the whole liability and you're being inconsiderate of what you're trying to deliver. And just so you know, there is legislation in most jurisdictions that will cover the fitness of purpose, so that the service or product you're delivering is fit for the purpose that you're selling it for. So obviously nothing unrealistic, right? So it should be within realistic expectations, but make sure you can limit wherever possible, and wherever it's realistic to do so, that you're not assuming any extra responsibility on your own initiative. Assuming extra responsibility when it comes to contracts is not really a good thing. It doesn't show that you're going the extra mile, probably the opposite. Including a force majeure clause, which relieves you from breach if unforeseen events occur. Okay, so this is a huge one, and probably with COVID, you might have come across it or seen a webinar because it was a very hot topic. Force majeure is not acknowledged by all jurisdictions, and it's not put in quite a few contracts. So you have to, like, from my personal experience and over the pandemic especially, this should be there. So what it does is it does give you the options in unforeseen circumstances such as a pandemic to be able to terminate the agreement without liability or put it on hold for a while or renegotiate. It depends really how you're going to state that clause, because one of the examples I give, one of my clients was a cruise liner, and we had a lot of contracts that had to do with like delivering catering and the laundry services on board, etc. And unfortunately, most of the contracts I didn't draw them up, just to make it clear, they were there before I joined. There was no force majeure contract. We also didn't know COVID would come along, so I guess that's a good excuse. So there wasn't a clause there, and that meant that we had to go and try and seal a new deal from the beginning and convince the other party to come to terms with that, for the next year or so, we will not be needing the food that we've agreed that we need on board. We will not be needing the internet services because obviously the cruise sector went on hold. So this is quite important to put there within the contract. What would happen in such an event? Something unforeseen, something that disrupts your business operations. Because it could happen. For example, it might not be your fault. There could be a strike. There were a lot of also issues with the shipyards going on hold from the maritime sector, so that created some issues there. So that's quite an important clause to have there and kind of fine-tune it to what you would be able to do. Will you be renegotiating? Will you be terminating, etc.? What's the period? What's a grace period that you will be getting, and vice versa, of course. And include a dispute resolution clause, and make sure to designate the governing law and venue for dispute resolution. And to simplify that, so in the event that something does go wrong and you do have something that needs to be taken up with a court or an arbitration, make sure in that contract you've got the law that will be governing it, right? So if you're based in the UK, that would be UK law and UK jurisdiction. If you're based in Cyprus, it would be the Cyprus law. Try and pick the law that accommodates most of your operations. So even if you've got operations in a few countries, try and see where you mostly operate, where you're most confident to take up any disputes at court. So determining the governing law and seat is quite important in the contract. I know as startups, sometimes if you're working with the bigger companies, you don't really get an option on the contracts, and you might be forced to agree to some terms and conditions that are not so favorable for you, or go along with the governing law and jurisdiction. If that is the case, and I would suggest, like, make sure you have your legal counsel screen it, try and get the best deal for you, but also like be prepared and have a strategy. So if, for example, one of the companies you deal with most has a jurisdiction in, I don't know, where should I say now, in Manila, I'm saying, try and make sure that you've got a counsel also on that side, and somebody you can contact in the event that something goes wrong and that you trust, or that can guide you through and make sure that there's nothing in there, or also make you aware of the protection that you have in that jurisdiction. Because no matter what you put in the contract, sometimes the law might supersede it, as I mentioned earlier, like the fitness of purpose of a service or a product. So it's good to know like whether this contract is fair under that jurisdiction and what you can do about it. There's a question here. Chris, that's okay. We'll be sharing the replay, so that's absolutely fine. You will have like 30 days to see it on replay. Thank you very much for joining. There was a question here. If we were in a situation of building a contract with a supplier, could we get some support from you or one of your colleagues and party? Yes, of course you could. As I said, please do reach out. I'm also going to put at the end of the slide, you or everybody participating today, you can call me for a free discovery session and see what you need, and then we can just take it from there. So that's great. Is there, Rita is asking, is there a reliable site where we can access the tax treatment of different type of companies, at least across the EU, so that we can assess that aspect on a comparative basis? Rita, I would say, especially for the EU, you might find lots of information on the Big Four. So they usually issue booklets with the kind of tax, or they've got Q&A sections on the websites. But as I said, you can also contact us for something like a specific question, and I can send you through links and publicly available information that is quite reliable, and you can get a general idea. But if it's a serious consideration, I'll always advise, do make sure you do get professionals on board. I know it's an extra cost. I know sometimes you're trying to alleviate that burden, but it could turn out into, you could save you money, and it could turn out into a mess if you really haven't got this handled going forward. So yeah, yes, I will be showing my email. Let me also just show it here. So it's enter@oceans. That's my email. So yeah. Mistake number 11. So not having a good terms of use agreement and privacy policy for your website. Okay, so this has to do with your virtual presence. You've probably, most of you might have a website already, or are working on it. Again, it really depends on what your website is doing, whether it's storing any data, whether people are downloading stuff from it, whether it's a membership kind of a website. It really depends, but the general kind of guidelines is that you have to have a good terms of use agreement. In most jurisdictions, this is not absolutely compulsory, but I would suggest it for the same reasons that I say have a contract in place with your shareholders. After your shareholders and co-founders, the most important persons are, of course, your clients. So you have to make sure you've got those terms set out for them. I'm not very into using too legalistic language, so the simpler you can keep it, the better. You can find lots of available templates online for this. If you do not want to hire legal counsel to do it for you, just make sure you fine-tune that. Keep it simple and make sure it's relevant to what you're doing. Just don't copy paste anything. And then what is usually required by law is a privacy policy for your website. In most jurisdictions, this will be a prerequisite, especially in EU, where we've got obviously GDPR, or anybody dealing with EU people in the EU or companies in the EU. So coming onto a good terms of use agreement should be covering ideally the following. So how the site can be used and any limits imposed on users. Disclaimers and warranties, limits on liability of the site owners and its employees, officers, affiliates, and directors, how disputes will be resolved through, for example, will it be a confidential arbitration? Will it be a court? So will it be litigation? Representations and warranties of the site user and indemnification of the site owner, rights to refunds and returns if products are being sold online, so if you've got an e-shop, and your intellectual property rights. So make sure, firstly, you've secured your intellectual property rights, copyrights, patents, etc., and make sure that that's written on your website so people know that you've got the right IP in place. Somebody send a message through in respect to employment. We will be covering it in the next slide, so stay tuned when recruiting people. Now onto a good privacy policy. As I said, this is required by law in most jurisdictions. So it's very important that you have what information the site collects. how the site uses the information, how the information is shared or sold to any third parties, if that is the case, how the site deals with children, especially a very sensitive issue, how the site can be accessed through third-party services such as Facebook and Twitter, a description of the use of cookies and other technologies on the site, the steps taken by the site owner to protect confidentiality and security of the information collected, how changes to the privacy policy may be put into effect. As I said, you can find a lot of publicly available information, and you can also, fine-tune your search on what you're doing. If it's, for example, a networking platform, you can even go to Facebook and see what they've got there and try and use that, but make sure it's not copy pasted. Make sure you tailor make it to your needs, because you do not want to be undertaking or making any representations that do not reflect your own company, because that's available on the web and people can use it against you. So make sure it's tailor specific. Again, I would really strongly advise you get somebody who has done privacy policy before to do it for you, or review it for you, worst case scenario. So these are also quite important. But what I would also say is, if you're collecting data, make sure that you're also compliant with what you're doing and how you're processing that data, etc., with the regulations within your jurisdiction. So, for example, if you are collecting data via the website, like emails and stuff like that, who has access to that? And also consider, do they need access to that for what they're doing? This is quite important. And also, do they need access to all the information that you're collecting? So, for example, you cannot be, providing a solution for cleaner water, for example, and then be asking the person submitting a form what their height is or what the gender is, and have that publicly available to your whole team of 5 people. That will be like, any information you're collecting has to be relevant to what you're doing and has to only be visible to the people that need access to that information, absolutely need access to that information. So these are a few considerations when it comes to terms of use and policy. That was quite a long slide. I'm sorry about that. I know legal stuff really could get, there's a lot of things up there. So mistake number 12, we're almost done, we're reaching 16 soon, is not using a good form of employment agreement or offer letter when hiring. So if you are hiring, if you're in that stage, or if you're thinking about scaling up, and hopefully I wish the best of all of you to become as big as you dream of. Employing people is not as simple as it seems. And for those who have had the experience, you probably know already. For those who haven't, good luck with the first recruitment. It's a fun process. So things that are obvious, but you should be taking into consideration, is obviously the job title, the role, the responsibilities of the employee. Whether the job is full-time or part-time, this is also crucial when it comes to your payrolls and your taxes. I won't go into too much detail because I'm not an accountant, so it's not really my thing. But these are quite important, like whether it's full-time or part-time, etc. So when the job will commence, how long the offer of employment is open to the employee, the salary, benefits such as any vacation, any relocation expenses, any other bonuses, whether the position is at will, meaning that either party is free to terminate this relationship, or whether there's a penalty or any notice they should be giving. These are all very important things. So some contracts are also fixed term. So you might bring somebody on for 6 months or for 12 months. Make sure it's in the contract, and also make sure that the employee is aware of this before they sign, because you do not want to be making any misrepresentations through this process. And also make sure you've put in there what the termination period is. So most countries, all countries, would actually have some kind of a notice period depending on how long somebody is working for you. It's probably best, especially if you're hiring somebody who's going to be quite an important part of that team, to have a sufficient notice period that will cover you to be able to replace that person and for a proper handover to be in place, etc. Having said that, from personal experience and having also worked in-house a lot, The contract is one thing and what the employee signs, but when it comes to practices and policies of your HR or personally, if you're undertaking recruitment, make sure that you have some kind of a reporting system and that either succession of this role or replacement of this role is a smooth transition. So you don't say if somebody has decided to move on and they're leaving in 2 weeks, you don't want to be rushing to get somebody in just to do a handover or have no clue what is pending. So make sure your processes are also in place and that employee is aware that they should be somehow reporting on the progress. There's so many available tools now, like Monday, I mean, where you can actually even tag people in it so you know the progress, etc. So try and have that in place aligned with your contract. Also confirmation that this agreement will not be changed unless the changes is actually put in a new contract or an addendum. So if it's a fixed term contract for a year and you want to extend it, put in the original agreement that this may be an option, or that if it is an option, it will be done in writing. Confirmation that the employee will need to sign a separate confidentiality and invention assignment agreement. Okay, I cannot stress this enough. A lot of people just take on other new employees, whether in startup or they take interns, like lots of interns, and they think, great, you know, it's cheap labor and they can help us out with all this administration. But these people are becoming a part of your team and they have access to what you've been striving to build, your legacy. So make sure every employee signs a confidentiality, even a basic one, and that they know what information they can share or not share, and that they also know their duty and responsibility when it comes to this respect. So as I said, it also has to do about the way you position yourself to your employee and to your customers, that you're taking this seriously, but it also has to do with safeguarding yourself and making that employee aware that, you know, this data you're dealing with, this process you've come into, it might be something like a summer job for you, but here, you know, this information is quite important to our vision and taking it forward and making it a success. So any stock or stock options granted to the employee subject to approval of the board and the terms on the vetting. So this kind of procedures, if you are going to be distributing shares to people joining, should definitely be considered and put in that employment agreement. And the supervisor to whom the employee will report, also quite important. Try and put those structures in place beforehand so people know what's expected of them. Unprotected language stating that the offer letter constitutes the entire agreement and understanding of the parties with respect to the employment relationship. So these formalities are quite important there. As I said, I could not stress this enough, so I devoted a slide on not requiring all employees to sign a confidentiality and invention assignment. This is mainly mistake number 13, but a recap of what I just said. So companies pay employees to come up with ideas, right? And work product and inventions that may be useful to the business. And employees have access to a good deal of that company's confidential information, which can be very valuable, especially in technology companies. So one basic way to protect this, again, it always comes down to trust and company culture. But a basic way to protect it is, of course, through using confidentiality and invention assignment agreement. So this agreement will deal with any confidentiality issues and ensure that the ideas, product, inventions that the employee creates and are related to the company belong to the company, not the employee. Do consult a lawyer on this, because sometimes and under some jurisdictions, you may or may not be allowed some access. So for example, in some jurisdictions, the email box that the employee is using can stay with the employee if he asks for that, or it can be deleted if he asks for that. So make sure you have an understanding of what kind of IP the employee has created, you have a right to, or you don't have a right to. This is also quite important when it comes to venture capitalists and other investors in startups who expect to see that all employees of the company have signed this kind of agreements. So this is more of a thinking forward and planning. But for example, in a merger and acquisition transaction in which the company is being sold out, the buyer's due diligence team and the lawyers will be all over the place trying to find these agreements and who has signed what, because they do not want to be investing usually great sums of money in buying a new company and then 2 months down the line find out that one of the employees went off and did exactly the same thing because he had the know-how or took that information with him. So similarly, it's also appropriate that all consultants of the company sign this confidentiality assignment agreements, and that these key issues are discussed with your consultants, and there's also an understanding of how you're dealing with them. So anybody, basically, service providers, vendors, contractors, any information you're exchanging, there's different type of confidentiality agreements, and I won't do a lecture. I could talk for probably a couple of hours on that alone, but there are unilateral kind of confidentiality, bilateral. So if you're both exchanging trade secrets or any information, you need to take this in mind. But of course, above all, is securing your own information and what you're sharing. And also, if you're giving them any documents to work on, so say if it's a project and you need to give them some plans or some reports or information, do put in that at the end of this project, everything will be returned to you. So all originals will be returned to you or destroyed if that is the case. So as I said, very important consideration. So just a few more to go. So coming on to now employment. Somebody asked a question. Okay, on employment. So I've already touched upon covering the contract side, right? Once you've hired the person. So this is asking interview questions that are prohibited by law. Okay. Things have changed a lot within the recruitment scene over the past few years. And maybe 5 years down the line, it was okay to ask somebody like how old you are and are you married? And probably in some jurisdictions, these things are already asked. And I know definitely as a woman, they will ask you if you want to have children, which is not allowed by law, by the way, completely prohibited, but still done. But hopefully our participants today are a much more forward-thinking kind of audience, and to be aligned with law, these are some questions you should know are prohibited to ask when you're taking on somebody. Like how old you are, what's your religion, do you have any medical conditions, have you been arrested or convicted of a crime. I know that for some jobs they might have to do a background check, and that's fine as long as you put that in your job description and say that if we do proceed to the recruitment phase, there will be a background check on you. Do you have any disabilities that will hinder you in performing the job? Obviously, you do have a right to know as an employer if your employee has disabilities, but only as long as it has to do with performing for the particular job. So not in general, just knowing if somebody has any disabilities, but anything that will affect them when it comes to the particular job. Have you had any recent illnesses or operations? This is a funny one, given that with COVID, that's the first thing probably everybody asks you. Have you recently had any COVID symptoms? But yeah, this is not allowed by law. Are you married? Do you have children or plan to have children? How long do you plan to work? Do you drink or smoke? What's your political affiliations? Is English your first language? What type of discharge did you receive from the military? What country are you from? Where do you live? Do you take drugs? And also some other more indirect, so less obvious questions like what's your maiden name? Because obviously if you're asking what's your maiden name, you can kind of figure out if the person is married or not. Do you own or rent your own home? So these kind of things are quite discriminatory. It's good to have them in mind when you're going forward with employment. It's also quite important for startups, I feel, because you're developing a new kind of culture, a culture that wants to be attractive to employees. It also has to do with your brand and the reputation you're putting out there, and people do talk. So just, having the courtesy to make sure that you also have quite a diverse and inclusive approach to your interviews, I feel it's definitely quite important. Now, when it comes to mistake number 15, I know that seems, wow, there's a lot of things up there. This has to do with not taking proper steps to firing an employee. I'll try and briefly take you in it because it's probably something hopefully you don't want to do or you're not in the process of. And it's never an easy process, but it would be good to know, I thought, just some basic stuff on it. So like making sure that your employee handbook has this policy set out on how you intend to act and what the disciplinary policies are, and the violations. So basically what is expected of your employee. This is a bit like the terms and conditions you have with your customers and your clients. So like what is expected of the other person is quite good when you're building a startup and a new kind of brand for yourself. So when an issue arises, investigate the situation to have a full understanding of the facts. Make sure you've done a good research because it could come back to you like a boomerang. I know most of you are thinking we don't have the time for that or whatever, but it is quite important. As I said, this does set your culture and how you're moving forward. So if the employee has poor performance or violates a company policy, make sure he or she has been coached or warned that the documentation of those communications is included in the file. A warning may be more appropriate than an outright firing for the first time offense, unless of course it's something significant, and do try and lay down these significant misconducts in your policies. Consult with employment counsel to ensure that the termination will not be in violation of applicable law. This is also quite important because sometimes you may think it's okay to fire somebody just like that, but it could not be the case. And what you may consider as a serious misconduct may not be allowed by law. Consider a progressive disciplinary approach first. So if the termination is not serious misconduct, try and deal with it with a different way, or by laying out what is expected of the employee going forward, or what is not expected of them, what they should not be doing going forward if it hasn't been clear enough. Conducting an exit interview is also quite important from an HR perspective. It's also good to try and have another company employee there to witness what was discussed, because you also get in writing like the reasons the person is leaving. It can also help you with your company going forward. But most importantly, if you've got in writing the reasons, they cannot go around and claim that it was something different going forward. And reputation is key, especially for startups and small businesses. Be brief, accurate, respectful, and truthful about the termination. That's probably being transparent is probably the best way forward in most situations. Make sure legal requirements are fulfilled. Make sure the employee has that the access they have to any computer networks, emails, is revoked immediately upon termination, unless of course you've agreed otherwise. This is highly recommended actually, to have an immediate kind of revocation, especially if it's gross misconduct, or especially if that employee is not being honest and is using something for their own benefit. It may not be operationally functional, but it does save you a lot of trouble. And probably even prior to the firing, actually, if you started to suspect somebody of doing of acting in an inappropriate and dishonest manner, maybe you should try limiting their access to what they had. Javier, that's absolutely fine. Looking forward to getting in touch. And as I said, the replay will be available for the next 30 days, so you can catch up on that. We're almost towards the end for the rest, so just on the last kind of mistake. At the exit interview, ask for the return, of course, of company laptops, phones, keys, securities, etc., that you have provided the employee, even if it's documents or reports. And especially with the working from home, a lot of people have had files and stuff at home. So make sure that everything is returned to the company. Make sure that the employee has the information necessary to obtain any unemployment benefits, etc., if that's applicable, that he understands that will have to continue under the confidential or with all the obligations assumed under the confidentiality agreement. Have them leave the premises immediately. I know this is very uncomfortable. Give them an opportunity, of course, to park their personal belongings, but sometimes it is necessary to protect your own well-being. Sorry. As I said earlier, in anticipation of any litigation, it does happen. I hope it does not happen to any of you, but it might happen that an employee might decide to go via the court route. That's why it's quite important through the process to get proper advice, but make sure that you've documented everything, as I said earlier, and make a plan for how the terminated employee's workload will be picked up by the other team members. This may also require some kind of debriefing, but as I said earlier, the best strategy is probably to have a process in place and a transparent kind of process where people from the team can actually follow through what that employee has been working for, because it could be gross misconduct. They might have done something that's seriously wrong and you might need to let them go immediately, and obviously they will not be willing to stand there and debrief the rest of your team on their responsibilities. So make sure you're able to track that down. And now coming on to my last slide before we go to the Q&A, that's just a thank you for following. And of course, my contact details, I've already put them in the chat. As I said, at Oceans Arena, we're a global legal network. So any jurisdiction you're thinking about, from, I don't know, UK, Cyprus, to even Malaysia, we've got a contact that has this kind of friendly approach to startups. And as I mentioned, because I know that was a lot to handle, probably everything wasn't really relevant to everybody. So you will all get a free 20 minutes discovery session. So drop me an email with that code so I know from which kind of training this is from. And we can set it up and just see what you need, simplify it, and see what you need going forward to make sure there's no mess and it's all success going forward. I'm sure you do amazing. And I think before we go into the Q&A, maybe I'll just pause the recording or stop the recording. I'll stop the share. And just a second to stop the recording so you can feel free to share your questions. Thank you so much for being here.